Today we're exploring how the concept of inventiveness, also called the inventive step, is assessed under the European Patent Convention. This is a core requirement for patentability, and understanding it is essential for navigating the European patent system. Let's start with our objectives. We'll look at how inventiveness is legally assessed, the role of the hypothetical skilled person, and how prior art plays into this assessment. Remember, inventiveness is not just technical. It's ultimately a legal determination. Inventive step is one of the main pillars of patentability, alongside novelty and industrial applicability. It's codified in Article 52(1) of the EPC. Just having a new idea isn't enough. There must also be a non-obvious technical advance. What is an inventive step? Article 56 of the European Patent Convention defines the inventive step. An invention must not be obvious to a person skilled in the art, considering the state of the art. This deceptively short definition is the basis for a lot of detailed legal and technical analysis. What constitutes the state of the art? The state of the art includes anything made publicly available before the filing date. Written documents, oral presentations, public use, and more. If it's publicly accessible without confidentiality, it counts. As a side note, what constitutes state of the art is also discussed in the video explaining the concept of novelty. Who is the person skilled in the art? This person is a legal construct, not a real inventor, but someone with average knowledge in the relevant technical field. They don't invent, they apply existing knowledge logically and are aware of the common general knowledge in their field. Identifying the technical field is critical. It defines the expertise of the skilled person and the scope of common knowledge. The technical field is usually derived from the problem the invention aims to solve. Have you ever heard about the problem-solution approach? This is the European Patent Office's standard method for assessing inventiveness. First, the closest prior art is identified, then the objective technical problem the invention addresses, and finally, whether the solution would be obvious to the skilled person. Sometimes, secondary considerations help in assessing the inventiveness of the invention. Inventiveness may be given when a long-felt need is solved by the invention, or the invention overcomes a technical prejudice, or if the invention achieves unexpected effects. These can be persuasive when the obviousness of the invention is debatable. This example illustrates a simple concept: a mug made from a specific material that changes color when the beverage inside is hot. The closest prior art is a standard ceramic mug. The thermochromic material serves to alert the user when the drink is hot or too hot. This invention pertains to the technical field of manufacturing tableware and comparable articles intended for contact with food. The closest prior art would be regular ceramic mugs and/or means to avoid burns when dealing with hot liquids, in particular beverages. The objective problem could be formulated to be, how can burns be prevented? The solution offered by the invention is use of an indication system, namely thermochromic material which changes color depending on the temperature. The assessment of obviousness for thermochromic mugs depends on whether heat-sensitive, color-changing materials were commonly employed to indicate the temperature of beverages, where the only distinction over the prior art is the substitution of a conventional ceramic material with a known thermochromic material. And such materials were already disclosed or suggested for temperature indication, and are free of ingredients that could be harmful in contact with beverages or food. The modification would generally be regarded as obvious. Conversely, if thermochromic materials had not previously been used in the manufacture of tableware or comparable articles, for example due to recognized technical limitations, such as the presence of non-permitted ingredients for food contact, then their application in this context could be seen as overcoming a technical prejudice. In such a case, the claimed subject matter may be considered to involve an inventive step. To summarize, the inventive step requires a non-obvious advance over prior art. Always consider it from the skilled person's perspective, and apply the problem-solution approach. This will help guide both patent drafting and examination. Did you like what you learned? Find more in our playlist.